I will call this hearing of Judiciary, Finance, and Civil Law Committee to order. Today is April 16th, 2024. A quorum is present. First item on the agenda is the minutes. May I have a motion to approve minutes for April 9th, 2024?
I'll approve the minutes, Mr. Chair.
Thank you, Lead Scott. Representative Scott moves approval of the minutes for April 9th, 2024. All those in favor say aye.
Aye.
Any opposed? The minutes are approved. I will read we have quite a few testifiers today, so I will read testifier expectations. All of the testifiers who have signed up in advance have been provided with a time limit for testimony. The time limits are provided so that we can keep the meeting on time and hear from as many people as possible. Thank you for abiding by that. Chair Becker-Finn, welcome to the committee.
Good morning, Mr. Chair. So I will move House File 4838 in front of the committee. And then we do have, I'm going to move, it's a DE, I'm going to move the A24-0278 amendment in front of us. So that's the DE that's in members' packets. And then I will also offer the A2 amendment to the DE. That is to reflect feedback from the Guardian Ad Litem Board and agreed upon language by all of the advocates and stakeholders who've been working on this group, on this language. So I would move the amendment to the amendment and open to questions if there are any.
Thank you. Chair Becker-Finn moves amendment to the amendment. Any committee discussion? Seeing no committee discussion, Chair Becker-Finn renews her motion to adopt the A2 amendment to the A24 amendment. All those in favor say aye.
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 Any opposed? Motion prevails. Now to the A24 amended as amended. Any member discussion? Seeing none, any closing comments from you?
Nope, it's a DE to get the bill in the shape we would like so that we can move it forward this year.
All right. The amendment has been amended, and it is before us. Chair Becker-Finn, I understand you have multiple testifiers. We now have House File 4838 as amended before us, and we will move to your first testifier. Chief Justice Rebecca McConkey Green, please come down to the podium.
Yeah, and thank you, Mr. Chair. And I just want to make sure we move the amendment before we move the bill.
My apologies. Where are we here? All right. Now to the A240278 amendment as amended. Any member discussion? Seeing none. All those in favor of the amendment as amended, please say aye.
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 Any opposed? Amendment passes. Now we have House File 4838 as amended in front of the committee.
All right. Thank you, Mr. Chair. And members, as you remember last year, we moved a related MIFPA bill. MIFPA is the Minnesota Indian Family Preservation Act, which is our state equivalent of the Indian Child Welfare Act, but includes some differences. There are a couple states that have additional protections for families and children, and Minnesota is one of those. I will just share as background, and I have shared this story before, but I do think, I don't know a Native person who has not been impacted by these policies in the past that divided our families and removed children from homes, removed children from their families often against their will or up against very difficult circumstances. And the ramifications of that really go on for years. For my family in particular, and I think also to just draw attention to the intersection of the other issues we talk about in this space around missing and murdered Indigenous relatives. My grandma, for example, so my great-grandmother was murdered when my grandma was 5 years old. And my grandma was then following sort of the trauma of all that and no longer having a mom there to fight for her, she was sent to boarding school along with some of her siblings. And I can tell you the impacts that had on my father's generation, on my generation, as far as disconnection from our language in particular. There were so many things that we would not talk about that nobody talked about. And I think stories like that are similar throughout Indian country. I don't know a Native family, again, who has not been impacted by this issue in one way or another. And so I think, we heard a lot of testimony last year and certainly appreciate the unanimous support in the House for the changes we made last year. But this year, we've had a lot of folks working in the background behind the scenes for a long time to clarify and strengthen some things in our Minnesota law, and that is the language that is in front of you. My testifiers will go into more detail, but one thing I wanted to lift up in particular is the on page 6, line 6.20 of the DE, making it really clear about inquiry at the outset about Native heritage. Some of the worst cases that have sort of gotten the most attention in the media over the years are often because of that issue, because some things were set into motion before folks realized that they should have been following ICWA, or they should have been paying attention to that heritage of the child. And so that's one piece that I think is in particular really important. There are also, it's a lot of pages, but a lot of it is just small edits. We do flesh out active efforts and what that means, as well as adding some more language around appointment of counsel in these types of proceedings. And I'm sure we will have time for discussion, but we do have a lot of testifiers, so I will turn things over to my testifiers.
Thank you, Madam Chair. Chief Justice, would you please state your name for the record and pronouns if you'd like to, and then proceed.
Thank you so much, Mr. Chairman. I'm Rebecca McConkey-Green. I am the Chief Judge for the Leech Lake Band of Ojibwe Tribal Court, and I'm very honored to be here this morning. My pronouns are she, her. And I have been, first of all, I want to also congratulate you and thank you very much. We had wonderful bill authors last year in Representative Keeler and I think co-authors in Representative Becker-Finn and Representative Kozlowski, and of course Senator Kunish on the Senate side as well, and many, many people who joined signing off on that. We were terrified last year when we came. There was a lot at stake, and so it meant a lot to see the legislature step up and support Indian people and tribes in that manner. You heard a lot of testimony last year from tribal leaders, but also from individuals who have been impacted by the system. And Representative Becker-Finn is right. I also don't know any Indian families that have not had struggles with child welfare issues throughout the years, including my own. I married a Leech Lake Band member who had 6 kids and I think about 14 grandkids. And so we have seen these processes in play in real time in our lives over time. Family is very, very important to Indian people and to their tribes. It's the very basis for how they go forward and continue to exist. And so it's very important that these things remain in place. We told you last year, I think I specifically told you when I testified last year, that we would be back. And we were coming back because that testimony from the people that were impacted was painful. We have not, when the Indian Child Welfare Act was passed in 1978, about 1 in 4 Indian children was adopted out to a non-Native home. We haven't really improved that very much in the interim. And while the Indian Child Welfare Act does a good job and provides a lot of protections that are very necessary, it was clear hearing that testimony that we need to do a lot better. And so the working group, last year, all the tribes in Minnesota got together and helped craft and create language for the authors so that we could make sure that all of the Indian Child Welfare Act was in Minnesota law. This year, we then, I should say last year, went and included the county attorneys and some other county players before we came to the legislature. This year, we started out with a huge working group right from the beginning. There were 187 people on my large email list. These are 187 people that got every single draft of everything that went out. Were invited to committee meetings. We had 10 subcommittees that worked on issues. And we drafted a lot of stuff. Some of that stuff came out in the end. Some of it came out during the process because either it needed more work or we decided it wasn't going to be something worth bringing forward. But we feel like we have a really good product in front of you. I did mention that we have some things that need some more work, so please expect us back again next year as we continue to try to make improvements. Basically, what this, one of the, I think the big things that this bill does is that the Indian Child Welfare Act and the Minnesota Indian Family Preservation Act apply to all proceedings that involve an Indian child, as defined by the Act, and where that child may be removed from the care, custody, and control of their parent, and they can't get them back simply by asking. So this isn't situations where parents are sending kids to a boarding school or just having relatives take care of the kids temporarily for a while. It does not affect custody between parents, and it doesn't affect juvenile delinquency types of proceedings. But any other time, so this would be probate actions when parents have passed away or are incapacitated and can't take care of their kids. It would be third-party and de facto custodian cases. Sometimes, every once in a while, domestic violence situations. And then, of course, custody. Not ever custody actions that are between parents. I think I forgot to mention that earlier, or between parents and Indian custodians. But if, for example, I decide to pursue custody of one of my grandkids, the Act applies. And so we haven't had in Minnesota very strong language making sure that we had all of the protection for the parents, Indian custodians, and children, and the tribes in laws and the other parts of the statute. We've kind of had some references here or there that the law may apply, I think, with some of the language. So one of the very important things we did this year was strengthened and made very clear that the law applies. If it's an Indian child, the law applies. Make sure that you're following it. We also made a number of amendments to MIFPA because it was, how can I put this? To make it a little bit easier to use when you're coming in from a non-child protection standpoint and be able to follow it. So there were some taken out of, for example, words like foster care and saying child placement and things like that. We also did some things to correct the fact that we didn't have very much in place for the other types of proceedings. So there is now additional language as stated about appointment of counsel. That's very important because often Indian parents or Indian custodians are in court unrepresented trying to fight for custody of their kids, and that the federal law requires that they be appointed counsel. We also have some language about making it easier for people to appear in court. I think everybody is aware from the testimony last year and probably just from your own learning that we unfortunately in the United States had a very tragic policy of relocation and termination of Indian tribes, which means that absolutely every tribe in the United States has people scattered all throughout the United States, including here in Minnesota. So we have 11 federally recognized Indian tribes in Minnesota, but we have people from all of the tribes probably in the United States here in Minnesota, or at least many of them. And it's very important that those tribes be able to be represented and be here. So one of our subcommittees worked on that issue and discovered that there were some problems with some of the requirements. It was making it very difficult for tribes from out of state to be here. So we have some language that cleans that up and allows it to be a little bit easier for them to be in court with their people, at least remotely when they can. And finally, I think one of the things I'm most excited about this bill is that in having discussions, we originally had some language about permanency timelines and wanting those to meet the federal guidelines. We, to make some agreements with the Guardian Ad Litem program, have taken that language out. But while we were having those discussions, one of the things that we realized was we don't have good evidence-based practice for a lot of the things that we're doing. I think the move towards having things be evidence-based practice is fairly new, and some of these things have been in place for a very long time. So we want to make sure that when we're going forward and asking you to do things like change permanency timelines or do something specific for kids, that we know what we're doing, or at least we have a little bit better idea of that. We don't know whether 12 months or 15 months is going to help a family reunify, and we don't know if 12 months or 15 months is really truly damaging to a child. So we want to know that. But we also want to know things like if the permanency for a child is that they return to their parent, or they go into long-term foster care, or they're adopted, what do they need going forward? And so we are asking for a committee to deal with that. So that is the bill in a nutshell, and I'd be happy to answer questions later. Thank you again so much, and I would ask you to pass this bill.
Thank you, Chief Justice. Up next, Lori York. Please introduce yourself, provide your pronouns if you like to, and proceed.
Alrighty, thank you. My name is Lori York, and I'm the Executive Director for White Earth Nation, and I am also the American Indian Child Welfare Advisory Council co-chair. My pronouns are she, her.
Proceed.
As you recall, last year, under the threat of the pending U.S. Supreme Court decision, the Minnesota legislature passed amendments to MIFPA that ensured all of protections of ICWA would remain in Minnesota. We want to thank you and the Minnesota legislature for your leadership in those protections by codifying MIFPA. Your responsiveness to the wishes of the tribes and the testimony of tribal leaders and Indian people set an excellent example for the nation. This year, the bill authored will improve practice in a manner that ensures greater protections for Indian children, their families, and tribes in the following ways. This legislation provides many practice improvements as it inserts language into several areas of the law where ICWA and MIFPA apply but are oftentimes overlooked. It provides a mechanism for appointment to counsel, to parents, Indian custodians, and Indian children in areas of law where counsel is not already provided for them. It clarifies notice provisions and improves access for tribes. It also ensures that tribes are able to provide input to the petitioners and the courts about what is truly in the best interest of Indian children. It allows courts to award costs and sanctions where appropriate when the court has invalidated proceedings based on violations of the law. So as you heard from Rebecca McConkey Green's testimony, there's a number of tribal attorneys and stakeholders, county representatives, the Minnesota Department of Human Services, the Minnesota Association of County Social Service Administrators, and the Minnesota County Attorneys Association that has worked collaboratively over the years for these amendments and changes. There was also a number of letters of support that were submitted, which included the Minnesota Indian Affairs Council, the American Indian Child Welfare Advisory Council, the Minnesota Chippewa Tribe, Fond du Lac, Upper Sioux, Leech Lake, and White Earth Nation. In closing, we appreciate any consultation efforts extended by Minnesota legislature with our tribal nations. We want to thank you for working in partnership with tribes, and we look forward to the continued discussion. We're respectfully requesting your support today on House File 4838.
Thank you. Up next, James Ryan. Please introduce yourself for the record, provide your pronouns if you'd like to, and then proceed.
Thank you, Mr. Chair. My name is James Ryan. I'm Deputy Solicitor General for the Mille Lacs Band of Ojibwe. Thank you for having us, thank you for having me, and thank you for consideration of this bill. Minnesota law states and recognizes that the best interests of the children, of Indian children, is interwoven with the best interests of the child's tribe. And as Judge McConkey Green stated, this is very important for Indian children, because a child's tribe provides them a sense of belonging, a sense of identity, and it is where the child feels they are at home. Knowing of one's culture is not the same as living in one's culture. And that is why the Mille Lacs Band has worked tirelessly to keep Indian children in their families and in their communities. Thank you to all who have supported the Mille Lacs Band and other tribes in this work, especially Representative Becker-Finn and all those who co-sponsored and voted on the MIFPA bill last year. 1 year ago, it was federal protection of Indian children and tribes were at risk. Minnesota stood up and said that no matter what happens in D.C., Minnesota will recognize the needs of Indian children and tribal sovereignty, and will respect it here in Minnesota. Thank you for that work. The work continues. Much of what we wanted last year could not be completed given the urgency and the timeline of what was ahead. The work continues here with important additions to the law and changes to the law and clarifications of the law. The Mille Lacs Band of Ojibwe asks that you support this bill. Thank you very much.
Thank you. Up next, Sadie Hart. Please come on down, introduce yourself for the record, provide your pronouns if you'd like to, and proceed.
Good morning. My name is Sadie Hart, and I am the Indian Child Welfare Compliance Monitor at the Indi Young Center in St. Paul. Indayang means our home in Ojibwe, and we provide a healing place within the community for American Indian youth and families to thrive in safety and wholeness. I also chair the Ramsey County ICWA Advisory Board, which advises the 2nd Judicial District and Ramsey County on issues relating to Indian child welfare, and co-chair the Metropolitan Urban Indian Directors Family Preservation Committee. In my role as the ICWA Compliance Monitor, I work with judges, attorneys, and other justice partners to make sure ICWA and MIFPA are complied with and implement best practices, specifically in Ramsey, Anoka, Dakota, Washington, Carver, and Scott counties. I want to bring your attention to 2 issues I commonly see that this MIFPA bill would address. The first issue is clarifying the court's responsibility to ask about a child's tribal heritage or ancestry, which needs to happen at the start of the proceeding and continue throughout the family's court involvement. Identifying Indian children early in the process ensures that they receive the full protections of MIFPA from the beginning, including active efforts to reunify the family as well as tribal involvement. Failing to identify Indian children can also delay the court process by needing to redo certain processes or invalidating the case. This inquiry is also required throughout the life of the case, so as new people, such as relatives, come to court, there's a clear obligation to ask about the child's potential tribal ancestry to make sure Indian children are properly identified. We frequently see these requirements being overlooked, so children don't get all of MIFPA's protections, and tribes aren't notified when their children are involved with the child protection system. The second issue is that we continue to see barriers that prevent tribal representatives from actively participating in the court process. Tribes have party status in MIFPA cases, but there is still a lack of understanding about the importance of their role, the valuable information they can provide in court, and how they collaborate with other parties. This bill addresses that issue by creating a definition for tribal representative and clarifying that a tribal representative does not need to be an attorney. Many tribal representatives are social workers and are at times not allowed to speak in hearings because they don't have legal representation. This bill also allows for tribal representatives to participate in court hearings remotely without prior request. Tribes have limited resources available to participate in cases and often have cases throughout the state and country. Making it easier for tribes to participate remotely means they can be more actively involved in the court process. These are just a few examples of how this bill would improve the experiences for an Indian child and their family in the child protection system and ensure that tribes are fully involved in the court process. Thank you for your time and for considering this bill.
Thank you. Up next, Lynn Braveheart. Please come down, introduce yourself for the record, share your pronouns if you'd like.
Good morning. My name is Lynn Braveheart. Pronouns are her, hers, she, hers. I'm sorry, I'm nervous.
It's all right.
My name is Lynn Braveheart. I come from the Oglala Lakota Nation from Pine Ridge, South Dakota. I work for the State of Minnesota Guardian Ad Litem program. I'm the ICWA Division Program Manager. I also sit on the ICWA Advisory Council as the St. Paul rep. I've worked for the ICWA, for the Guardian Ad Litem program since 2011 as an ICWA Guardian Ad Litem. Hennepin County was the only county in the state that had an ICWA-specific Guardian Ad Litem program. Since 2022, we expanded our ICWA division statewide, and we service every single ICWA case in the state. ICWA guardians are specialized in the 5 key areas of ICWA and MIFPA, and they are not lawyers. They do not have degrees. Not all of them, some of them do, but that's not what we hire them for. We hire people who are from the community, have lived and shared experience like myself. I grew up and aged out of the foster care system in the 90s. I have lived experience because my family, historically, my mother was part of the Indian Adoption Project. She was removed from her family and her tribe at 4 years old from our reservation in Pine Ridge. My grandparents were part of the boarding school era, and I never got to even see a picture of what they looked like until I ordered a book from a New Age store in New Mexico a couple years ago. The legacy of MIFPA is this, us sitting here today and repairing these wrongs that are historical. They didn't happen hundreds of years ago. It's happening right now to people like me, that who are just now learning about some of this history that's been invisible to us. And if we cannot uncover that and tell the truth about it, our families can't heal. It's called disenfranchised grief and historical trauma. And those terms are really, historical trauma is another way of saying genocide. Removing 1/4 of Indian children since then has been devastating to the intergenerational wealth of our people, not only socioeconomically, but culturally. So MIFPA is here to help us make sure that we are not removing 1/4 of every American Indian child. But it's not working yet. I'm hopeful it works. That's why we have an ICWA division. I'm hoping in the next few years, because of our hard work with the tribes and asking them to come to the table and tell us what they need, because they are the experts on their history and what works best for them, that we can move forward. I appreciate you listening to my story. I appreciate you supporting MIFPA from last year when it was so important, and supporting it today. So thank you very much.
Thank you. Up next, Sarah Davis. Please come down. Introduce yourself, say your pronouns if you'd like.
Good morning, Mr. Chair, members. My name is Sarah Davis. I use she, her pronouns, and I'm the director of the Children and Families Division at the Hennepin County Attorney's Office. I'm here today on behalf of our office to speak in support of this critical legislation. Tribal sovereignty is critically important. When tribal nations tell us which policies will protect their children and their families, we must listen. And although attorneys in our office actively participated in the drafting of this legislation, this bill fundamentally reflects the leadership of Minnesota's 11 tribal nations. You heard this morning already in your testimony how critically important this legislation is to moving forward the important work of protecting Indian families and Indian children. Some of the highlights from our perspective is that it codifies best practices by clarifying what actions are considered active efforts in returning children to their parents and custodians. It ensures, as you've heard this morning, that tribes have flexibility in their court appearances, allowing remote appearances at their discretion, which is really important because tribes may need to appear weekly or sometimes even daily at courts across the state. And it expands MIFPA to cover not just child protection cases, but it explicitly provides the same protections, for example, in third-party custody cases. Can't overstate the importance of this legislation. Appreciate the opportunity on behalf of the Children and Families Division of the Hennepin County Attorney's Office to appear before you today and share our support and ask you to vote in support of this critically important legislation. Thank you.
Thank you. That concludes our list of testifiers that have signed up. But before we move to member discussion, I'd like to ask if there are any individuals from the public that would like to testify. Seeing none, we'll move on to member discussion. Lead Scott.
Thank you, Mr. Chair. And I'm wondering if the Chief Justice could come back to the table. I had something I wanted just to get her feedback on.
Chief Justice, please reintroduce yourself and proceed.
Good morning. Thank you. I'm Rebecca McConkey Green. I'm the Chief Judge of the Leech Lake Tribal Court. Thank you.
Lead Scott.
Thank you, Mr. Chair. Chief Judge, I'm looking at section, page 6, and the language regarding, of course, you up front, down at the bottom of 6.28, the new language there, and it goes on to page 7, where you're trying to find out, is the child a member of a tribe? Could you walk me through practically how that works now, if that's something that you're familiar with, or maybe Chair Becker-Finn has an idea of how that works too? I'm just curious how you go about proving that a child is a member of a tribe.
Chief Justice or Chair Becker-Finn.
Okay. Is it okay if I go ahead? Thank you. So I have practiced child welfare since I began my career as a lawyer in 2007 and 2008, I guess, in state courts. So this is a very we have 87 counties, right, in Minnesota, and it's going to be a little bit different in a lot of them. What is supposed to happen in 2015, we added some inquiry language into MIFPA at that time, and so what was supposed to happen is that whenever a petitioner or a child welfare agency, potential petitioner, is having looking at possibly removing an Indian child from a home, they're supposed to be asking questions of that child's family, the parents, grandparents, anybody that they're coming into contact with as they go forward. And they're supposed to be asking questions about the family, their heritage, and even some more basic questions about what types of things did they do growing up, to kind of learn if maybe there is a connection that should be explored more. That's important because there were so many people, as you've heard through testimony today, that were removed from their families. So a lot of times in the past, part of what would happen is they would get the question, are you a member of a federally recognized Indian tribe? Many children aren't going to be able to answer that question. They're not going to know that. And even sometimes parents, especially if they were removed and didn't grow up close to their families, may not know, right? So we've been working for a long time to change that. When that inquiry happens, if there's anything that indicates that this might be an Indian child that's involved in the case, notice is supposed to be sent to the Indian child's tribe. And then the tribe looks at the information and makes a determination as to whether or not this is their child and a case that they should intervene and participate in. And hopefully that notice happen and that inquiry and involvement of the tribe happens long before a child is ever actually removed, because a lot of times tribes are very good at identifying services that might help the family, helping supplement some things for the family where appropriate, and identifying relatives so that if we are removing children, they're at least going to family members that will keep them connected to everybody. Sadly, learning is a slow process sometimes, right? So many years ago when I started doing this, I actually had an experience where I went into a court and got yelled at for being there because the county had determined that these weren't Indian children, and so we should just go home. It's slowly getting a little bit better. I think counties are much more responsive, and we're grateful for that, but there's still a lot of clarity that needs to come, and that's part of why we're trying to clarify these processes and make sure that people know what to do.
Lee Scott?
Thank you, Mr. Chair. Thank you, Judge. Do the tribes, like in the cases where these children, like Representative Becker-Finn, where the grandparents were removed, and how does a tribe keep track of, are there good records to go off of? Or, I'm just curious, with all the things that have happened historically, are there gaps in the record keeping?
Chief Justice or Chair Becker-Finn.
Yeah, so keeping in mind that every tribe is different and, runs their government however they're going to run their own government due to tribal sovereignty. But I can at least speak for my tribe, there's a whole division and people who are assigned to do that work. So there are records. It can get pretty complicated. We could spend a couple hours getting into the pros and cons of blood quantum and forced constitutions in the middle of the last century. And, there's a whole history there, but most nations keep their own records, and they determine that. And whether you are a member of a tribe, membership can also change from tribe to tribe. So different tribes can have different boundaries or definitions for who's included as a member of their tribe, because they get to decide that for themselves. But there are records. It's not like people are sort of making things up. And then on top of that, I know that they're constantly adding things. If there's more information that they gain from finding a new source, or if people have questions, they can contact that office about enrollment eligibility and talk to staff people within that office to find answers to their questions. So it isn't sort of just my grandma said, it's not that at all. There's actually documentation and a whole process.
Lee Scott?
Thank you. Just was curious.
Yeah, thank you.
Representative McCurran?
Thank you, Chair. And I just want to say thank you so much, Chair Becker-Finn, for your work in this area. I want to thank as well Reps Keeler and Kozlowski The three of you as the Native Caucus have been a powerhouse these last couple sessions. And I want to acknowledge that I know that when we work in spaces that are deeply personal, there's some additional stress. And so I just want to say that on the record, and I really appreciate the work that you and our colleagues have done to bring this to light and to do it with such thoughtfulness and grace. And I hope that as you retire and as you move forward, that if we don't gain any other Indigenous representatives, I hope that some of our other members might step up to the plate and carry on this advocacy work. So thank you so much.
Thank you, Representative Kern. Yes, Chair Becker-Finn, we're missing you already. Any further discussion? Chair Becker-Finn, closing comments?
Yeah, thank you, Chair, and I thank you for your comments, Representative Curran, and I will say it was intentional because we had so much testimony and kind of raw testimony last year. I didn't think it was necessary to sort of parade folks out here again when we all were here last year for that testimony. So I thank you for acknowledging that, because it does take a toll in different ways on folks to kind of reopen those things and talk about them publicly. So thank you for noting that. I just want to thank the amount of work that has gone on that all of us here did not see, because the folks who testified today were having the conversations and having the phone calls. And yes, there were that many people on the email list. So it was very, out in the open and inclusive. And I think that that's really important in how we got to a point where folks could agree on this language moving forward right now. And I just want to share, as I close on this bill, so just to make sure I got this on the record, we'll renew my motion that House Bill 4838 as amended be moved to the Children and Families Finance and Policy Committee, because there are some elements there that need to be vetted in that committee as well. And just share that, who we are and where we're from as Indian people is core to our very being. My children, despite being born in the Twin Cities and raised in the metro area, my 13-year-old will say things like, well, I kind of have two homes, Mom. Because he can, and they talk often, my children talk of going, we bring them back home to the reservation and their larger family there, and to be in that space with their people is incredibly important. I'm fortunate to have the resources that I'm able to provide that to them with transportation and everything, but that's ideally how our kids are growing up, where they're deeply connected to who they are and where they're from, no matter where they're currently attending school, and no matter who they're living with. And so I think that's just important to have on the record. The best interests of our children is that they maintain meaningful connections to their tribe and where they're from, and that's really the heart of what we try to do with this kind of legislation. So just thank all the testifiers and all the work that's gone on. Chimigwich, appreciate all of you so much. With that, would renew my motion.
With no further discussion, Chair Becker-Finn renews her motion to re-refer House File 4838 as amended to the Children and Families Finance and Policy Committee. All those in favor say aye.
Aye.
Any opposed? Motion passes. You're on your way.
Thanks for letting us play musical chairs there. Representative Bahner, I will move House File 2257 to be referred to the Ways and Means Committee. I will note, too, that we did hear this bill with public testimony earlier this biennium in 2023, but there's some data provisions that have been changed, and so we're bringing this forward again for committee review. So with that, the bill is in front of us. Representative Bahner, please tell us about your bill.
Thank you, Madam Chair and members. That is correct. We have been before you in a previous session. I'm proud to be back here before you today, though, with the Minnesota Age Appropriate Design, also known as the Minnesota Kids Code. This bill has made many improvements from its last iteration, drawing on legal and technical expertise to better define terms, specific harms, provide more clarity for judges and businesses alike, and strengthen it against legal challenges. The bill before you creates a framework to protect kids through the highest privacy settings by default. It regulates how businesses can manage sensitive data to use to target children online. More importantly, it asks businesses to do one simple thing: to design their products through the lens of child safety, like every product on the market. Tech should not get a pass on building safe products. This bill is reasonable, logical, and measured. It's practical. It uses existing best practices already used by businesses today to assess and mitigate risk, prevent harms by making better, smarter design choices. This bill and this issue transcends political ideology and party lines, and it unifies, I would argue, every legislator here today. We can build better, safer online products by design, and we can put kids over profits. Specifically today, we are here to address 3 points. I will outline them briefly and then pass it to my testifier to go into more depth. But we are first here to talk about Section 1, Subdivision 1, the Attorney General's data, which is coded elsewhere on lines 1.8 through 1.14. Section 6, Subdivision 3, which speaks to data practices on lines 11.6 through 11.12. And Section 7, Subdivision D, the lines 12.3 to 12.4. And with that, I will pass it to my testifier.
All right, welcome to the committee. Please introduce yourself and proceed with your testimony.
Hi, thank you, Chair and committee members. My name is Nicole Rocha, and I am a consultant with the Omidyar Network. At its core, the Kids Code is simple consumer protection, and it will revolutionize kids' experiences online for the better. What perhaps is less obvious is how the bill is also narrowly tailored to incentivize compliance and promote ethical innovation. Specifically, the Kids Code is exclusively enforced by the Attorney General and does not include a private right of action. Because the code is a design bill, there is no need to wait for one more child to be harmed before bringing legal action. Rather, violations are based on product design decisions that could affect every child in the state. And the AG can demand that these design decisions that create serious risks of harm or discrimination are corrected before more children or families suffer. Excuse me. The bill also includes a 90-day right to cure for businesses that are in substantial compliance with the code, ensuring that platforms have flexibility to innovate without fear of liability, so long as the products are designed with kids' interests in mind and tested for safety. Finally, to promote thorough assessments, the code ensures that impact assessments are protected from public disclosure and that the act of turning over impact assessments to the AG's office does not waive any privileges the platform holds, such as the attorney-client privilege or a work product privilege. In addition, the bill before you has important changes from what this committee heard last year. These changes maintain the principles of strong data privacy and safety, but incorporate language to make the bill more defensible from legal attack. In summary, the bill defines the best interests of children using harms recognized by U.S. courts for decades from tort and discrimination law. It strikes any reference of the word content from the bill, except to clarify that the bill shall not be construed to limit a minor searching for content. The bill now states that it does not interfere with any existing rights or privileges of children. It ensures that there's no requirement for age assurance, and even if a company does decide to estimate age, they must do so in a privacy-protective manner. There is a narrow carve-out for journalism, and businesses have been given 2 more days to comply with requests from the Attorney General. Finally, it is important to note that there is a lawsuit going on in the West Coast, and that decisions of the Northern District of California and even the Ninth Circuit of Appeal are not binding on Minnesota. In fact, widespread outrage about how the district court erred in its application of the law and its understanding of harms kids face resulted in more than 60 experts and advocacy groups collectively representing more than 1.8 million Americans, submitting amicus briefs in support of the California AADC. They warn of countless types of consumer protections, not just those applied against online platforms, but in every sector that could be invalidated if the district court's opinion is allowed to stand. The time for Minnesota to act is now. Youth want a better online experience, and parents are begging for help. Far from being a burden, the Kids Code is simple industry best practices and frankly basic decency. I'm available to answer any questions about this important measure.
All right, thank you for your testimony. Next up, I have Shamel Henderson. Welcome to the committee. Please state your name for the record and then go ahead with your testimony.
My name is Shamel Henderson. I'm 16 years old and I live in a loving and protective home. I request you support the SF 2257, the Minnesota Age Appropriate Design Code. When I was 12, I started getting constant information online, images no child should ever see. Drugs, violence, and cyberbullying. People started getting recommended to me as suggested friends on Facebook and other platforms. Naively, I accepted their requests, unaware of their intentions, blind to the dangers ahead. I didn't know they were adults and not friends at all. I didn't know they were grooming me or they had a plan to make me feel insecure, to question my appearance, my worth, and my identity. I began asking myself, was I skinny enough? Was I pretty? Did I have the right clothes? The more information that was sent my way, the more vulnerable I became. Then at 14, I was lured, kidnapped, and trafficked for a whole month by men posing as appeared to me, a 27-year-old man. Working with a ring of people. I have spent 2 years healing and reclaiming my sense of self, thanks to the support of my team and a great therapist. I'm well enough and strong enough to be here today. Here to ask you, do you think what happened to me is okay? What will you do to prevent this from happening again? I'm here to ask the companies, why won't you do anything to make sure grown men can't track or traffic a young girl like me? I don't want what happened to me to happen to another child. I want you to make sure make safer online spaces where youth can explore, learn, and grow without being groomed, preyed, and stalked upon. Okay. The responsibility to keep kids safe online shouldn't rest on us. The companies who make these platforms should make them safe for us. People, please do what's right and make online platforms safe for me and kids just like me. Thank you.
Thank you very much for your testimony. Are there any other members of the public wishing to testify on this bill? All right, not seeing any, we will move on to member discussion. Representative Niska.
Thank you, Madam Chair, and thank you, Representative Bahner, for your work on this issue. You're right that, I mean, this is an issue that touches all of us. I do have some concerns sort of workability-wise and in terms of, you know, the legal challenges that you touched on. And specifically, I wanted, you and your testifier talked about this being strengthened to under legal challenges, and I, you know, there is this case out of California, currently appealed up to the Ninth Circuit. There are amicus briefs on from a lot of different folks. I mean, there is an amicus brief, for example, from the ACLU, arguing that there are aspects of the California law that are unconstitutional that should be struck down. So Of course, what the Northern District of California does, or even what the Ninth Circuit does, isn't binding on us, but they are trying to interpret the same binding Supreme Court precedent that is binding on a case in the District of Minnesota. So I just want to understand what legal features of this bill, if we were to pass it, would be different or factually different from the bill that is being considered by the Ninth Circuit out of California.
Representative Bahner.
Thank you, Representative Niska. And I know during Ms. Rocha's testimony, she actually outlined a number of the changes that we've made on this bill since. One of the main was clarifying, sometimes words matter, as we know, right? So making sure that we were very clear that the only reference to the word content in the entire bill is specifically giving permission to say that nothing in this bill would prevent children from searching for content that they are actively looking to explore, right? So in other words, we're not looking to hamper children from their ability to use the product. But it very clearly does not state that anywhere else in the language. That's intentional, right? Because we don't want to give even the slightest impression or misinterpretation that this bill is about content rather than design. And I think one of the fundamental challenges that we hear from a lot of the opponents is a really clear misunderstanding of tech, right? That when we talk about design, we're talking about features, functionality, we're talking about code. We're talking about the way that the product designs and functions in the world and the way in which we interact with it. We are not talking about content. And so, to be honest with you, as a technologist, it's a little bit insulting because I know the folks who build these products. I know how innovative and creative they are. And I know that they have a million tools in their toolbox. And when we say that we want businesses to be innovative, to have the ability to do that, that's exactly what this bill does. It says, look at the design of the product. Make sure that it is inherently safe from the outset, and that we're not limiting people's ability to interact with the product per se, but that we are making sure that when they interact with that product, that it's safer. And so I think that a lot of those arguments are a little bit disingenuous. And so I would say that is one of the biggest changes that we made here. The other is, talking about things like the reasonable standard that courts can apply. So that makes a little bit more sense. They had asked for better definitions around things like age appropriate, and what does that mean, right? So if they're using that information to inform their data privacy impact assessments, they can use that information. So those are some of the key things that I think we have changed. We've also made clarifications around Section 230. While we do not provide any specific information about what tools they should use or code they should use to design their product, we do specify that should they use a tool in their toolbox that strays anywhere near that avenue, that federal law obviously trumps state law in that regard. And so in that process, we're also saying to companies, we understand that you should use the best tools you have available, but if you go down that road, you're protected under federal law.
Representative Niska.
Thank you, Madam Chair, and thank you, Representative Bahner. I guess I wanted to zero in on one of the things you said, which was that you're trying to cut out anything that touches on regulation of content, and there's only one reference to content, or at least use of the word content. I guess I am concerned whether, to what degree, references in the data protection impact assessment about, for example, on 8.12, whether algorithms used by a service, product, or feature would result in reasonably foreseeable and material physical or financial harm to the child, reasonably and foreseeable and extreme psychological or emotional harm to the child. And it goes on with similar words like that, which seem to tie at least to the concepts of what content a child would be accessed. I mean, we're talking about technology, right? And so the harm to the child would be from content that the child is exposed to. And I guess I'm just trying to understand, what is the what is the legal import of the data protection impact assessment here, especially in light of Section 4 of the bill, which this language on 6.5 through 6.8, I'm just not really understanding, like, what does that mean and how does that affect or how does that tie together with the data protection impact assessment? It does seem to me like those things in combination are regulation of content in this area, and it's not quite satisfactory to just say we're not regulating content.
Representative Bahner.
Thank you. I will say, first of all, when we talk about the idea of being on 6.5 to 6.8 a fiduciary, I think we all understand that to mean that we're placing the best interest of that child or that consumer above the profit that we're hoping to make off of this product. And to be candid, I struggle with this a little bit in that, we have allowed tech in many ways to design features and functionality where they are collecting vast amounts of data on our children. And they are literally encapsulating that data into a product. We are monetizing our kids and their data before they've even reached the age of consent. And I don't know if that alarms you, but it certainly does to me. And I know Representative Scott, for example, has a heavy interest in the use of data. And I appreciate her perspective. And I will say that I think we share that. That is unacceptable. And when we talk about physical harms and things like that, we can talk about features and functionality that are not content related, right? So, for example, giving children the ability to be contacted by random strangers, that's a feature of a product. It's not content, right? But it can cause significant levels of harm. And in fact, there was a recent study that just came out, and I want to bring it up here because I think it speaks to that idea of physical and mental harm. The American Psychological Association just released a report on social media and kids. And there's something really important that I want to just briefly say. It said brain development starting at ages 10 to 13 at the outset of puberty and until approximately the mid-20s is linked with hypersensitivity to social feedback, stimuli. In other words, youth become especially invested in behaviors that will help them get personalized feedback, praise, or attention from peers. Policies will not protect youth unless technology companies are required to reduce the risks embedded within the platforms themselves. And let's just be clear. Every company that we're talking about that is not acting in good faith here, they are well aware of the dangers that some of the features and functionality of their products hold. They have the internal data that shows the harm. We have whistleblowers like Frances Haugen, who was the head of safety for one of these companies, and said point blank, they know their product is harming children, and they're choosing not to build and design better products because they are literally choosing to put profit over our kids. And I think that's a really important distinction. And I think it's really also important to understand that a lot of the social media companies have been talking a lot about constitutionality and pushing this idea of content. And one, I would say they haven't read my bill because this bill is not about content, it's about design. And secondly, it assumes that the people sitting around this table don't understand the tech either, that they're not smart enough to see through that smokescreen. But I have to tell you, as a technologist for over 30 years, who works with the folks who build these products, I know that's a smokescreen. I know the tools that we can employ to build innovative products that will be used, that will be engaging, but that don't have to addict our children, that don't have to create the level of harm that they are. We have the ability, sitting around this table, to change that. And frankly, saying to one industry that they should not have to think about child safety where every other product, every other industry must, is simply wrong. And I hope that answers your question. I will certainly allow my testifier, if she has any additional pieces, to weigh in on that.
Sure, thank you.
Yep, hold up. That was a very long answer, so I'm going to go back to Representative Niska.
Yeah, thank you, Madam Chair. And Representative Bahner, I agree with a lot of what you said about the problem. I don't think I heard a lot in terms of an answer to the question. Certainly, it's true that regulation of data and data collection and use of data is a pretty fundamentally different thing than regulation of content. I guess I'll just wrap up by saying my concern overall is I think regardless of whether we say as a Minnesota legislature that the decisions of the Northern District of California are not binding, if we don't give, if we pass this law, Net Choice or somebody will sue, and it'll be in the District of Minnesota, and the easiest thing for a district court judge in the District of Minnesota to do is to say, well, there's this opinion, this federal court opinion from California that analyzed a very, very similar bill and held it was unconstitutional for these reasons. And that's, fairly well put together and a decent good faith analysis of U.S. Supreme Court precedent. And I just don't think that's a useful road for us to go down, even though I agree with a lot of what you say about, concerns about tech in our kids, and that there is, I think, more that we can do than what the industry groups will agree with us as constitutional. I think those are all fair points. I just think this model is just, is going to look to the courts like a do-over of what they did in California, and it's not, I don't think it's the right path for us to go down as a state.
Representative Feist.
Thank you, Madam Chair. Thank you so much, Representative Bahner, for working so hard on this bill. I think it is so important. Just yesterday, I finished reading Jonathan Haidt's new book, The Anxious Generation, talking about how technology and cell phones specifically have rewired childhood. And the data is global. And there is no question that the introduction of smartphones really impacted child well-being, mental health. And so we have to do something. And so I thank you for all of your hard work on this. I wanted to respond to the letter from TechNet talking about how age verification is just so complicated, we could never possibly do it. They should read Jonathan Haidt's book because he had a whole bunch of ideas, and it seems eminently doable, and they put together these highly complex, effective products, and I bet they could figure this out. Because I know my kids are 12 and 14, and their kids lie, or their friends lie and have social media accounts and are not old enough to have them. And then they sit on social media instead of socializing, and it's a huge problem. So I have faith in the tech industry to figure this out and develop age verification tools. If we were going to just do like one really super simple bill, I would say like raise the age of internet adulthood to 16 and mandate age verification. And we'd solve a lot of these problems. So let's do that too. So I just wanted to end with kind of Jonathan Haidt's kind of central thesis is that we have a collective action problem, that individually kids hate what the internet is doing, what social media is doing to their lives and their relationships. But they don't want to be left out. They know that when their friends all have social media and Snapchat and Instagram, that they don't want to be the one who's not part of that community. And the data shows that if asked if everybody gave up social media, would you? They're like, yes, let's do that. And so we have this collective action problem, and it then falls to us as a society and a community to do something proactive and large scale. So I think this is just really hugely important, and I thank you for your work.
Representative Scott.
Thank you, Madam Chair, and Representative Bahner, thanks for your work on this. I do have some concerns with it. Of course, everyone agrees with why we're here and what you're attempting to do. I'm just not sure this is the answer, and I would tend to agree with Representative Feist that it might be simpler than this. It's age verification, and another thing is just positive peer pressure, right? And parents deciding altogether, hey, we're not going to allow our kids to have smartphones till they're 14 or 16 or whatever. There's plenty of data out there now and research showing us, you know, when this stuff is age appropriate to allow your child to have access to. And I know I've done some research in the past too on some of this subject matter, because one of the common issues that I have seen in my reading is that the average age of a child's first exposure to pornographic images is like age 8. And you know, it desensitizes kids. And I have so much concern over that particular issue. And globally, not just in tech, but globally, what we're doing to desensitize our kids sexually and what that means later on in their life, or can mean later on in their life. And so one of my issues with this bill is who determines what is age appropriate. And I have a friend whose daughter is a nurse in postpartum, and she had a 12-year-old mom recently. 12-year-old mom. And so that's really, really young. I don't know how it started with her being sexually active, but it wouldn't be far-fetched to kind of draw a conclusion that she may have been exposed at an early age to some of the stuff that sexualizes kids before they're ready to be sexualized. And so, Representative Bahner, if you could address more of that question that I have about who determines what is age appropriate.
Representative Bahner, briefly, because we do have another bill and we have some testifiers, several testifiers on the final bill.
Yes, thank you. I will say this, and I will give my a testifier a chance to weigh in, but here.
Representative Bahner, if you just answer the question, because
Yep.
I'm afraid we're going to run out of time.
Yep. I was going to say, in terms of age appropriate, there are piles and piles and piles of data on what is not age appropriate. That really isn't much of a debate, but for the purposes of our argument today, we have outlined what those ages are in the bill so that they can serve as a guideline to help companies establish whether or not children within those age ranges might be impacted by their product. And those are based on evidence that is widely accepted across multiple disciplines. And with that, I'm going to actually give it to my testifier to speak a little bit deeper on that.
And actually, Ms. Rocha, really briefly, 30 seconds.
Sure. So there are guidelines put out by a lot of national groups, the American Association of Pediatrics, and all sorts of different things that talk about, you know, the developmental stages of young kids. For sure, we've seen all of those. No screen time before 2, all of this. But additionally, there are guidelines for different age brackets as kids are getting into teenage years, you know, what social media does to their brains, how important it is for them to be liked. And these are the kinds of things that people should be taking into consideration, because the problem with the way that the internet is currently working is that platforms are exploiting, you know, teens' vulnerabilities. And if they're not permitted to do that, perhaps, you know, unknown adults wouldn't be able to message minor women, minor girls, and you know, we could avoid, you know, what happened to Shamel, but like, honestly, it was about maximizing attention. It was about making her feel insecure about her body. That would keep her on screens, keep her online, and that made her victim to adult predators online who are also not being stopped, because the goal of the platforms is to maximize the children's time online.
Representative Scott.
I'll leave it there, Madam Chair. I know we're stretched for time here, but those are my main concerns, or the main concern I have is just who's gonna define that, and that's murky legally as well. So thank you.
Thank you. Closing comments, Representative Bahner. If you keep it tight, we have folks who've traveled here under, takes a little bit more difficulty for them to travel here than our other testifiers.
Absolutely.
So Representative Bahner.
Thank you, Madam Chair. The Minnesota Kids Code is a product safety bill, plain and simple. It asks businesses to apply a lens of child safety to the design of their products through widely used best practices and to protect the safety of children online. It asks companies to use the highest levels of data privacy by default to protect the privacy of children. Tech companies choose to place profit over our kids. No Minnesota parent believes this is acceptable, and neither should you. It's time for tech to be held accountable in the same ways that every other industry is responsible for the safety of children. Parents are asking us to act, and Minnesota legislators have a duty to protect our children. I ask for your support of House File 2257. Members, it's time to put kids over profit.
All right, I'll renew my motion to refer House File 2257 to the Ways and Means Committee. All those in favor, please say aye. Aye. Opposed? No. Motion prevails. All right, Representative Hicks. I will move House File 5049 be referred to the Children and Families Finance and Policy Committee. And then I understand you have a technical amendment, Representative Hicks, so I will then also move the A1 amendment. It says incorporates feedback and technical corrections to make it match up with the Senate language. All those in favor of the A1, please say aye. Aye. Opposed? All right, motion prevails. The amendment is adopted. Representative Hicks, to your bill as amended.
Thank you, Chair and members. I had some kind of amazing opportunity to speak to you this morning. I was going to share all kinds of stuff, but I have people who can share a lot more and a lot better. So what I will say is that this bill works to fix systematic ableistic practices in child welfare, adoption, and child custody. And my testifiers can share a lot more what that looks like and why this bill is needed. So I will defer to them.
All right, first on the list, I have Corb O'Connor. If you can please introduce yourself for the record and then proceed with your testimony.
Thank you, Chair. I'm Corb O'Connor. My pronouns are he, him, and his, and I'm the president of the National Federation of the Blind of Minnesota. We are the transformative membership and advocacy organization that's been working to advance the rights of Minnesotans who are blind since 1920. I'm excited to tell you that so many of us made it here this morning thanks to Uber, Lyft, and public transportation, and that's just the same way that we work with our kids. You know, as a disabled parent of a blind child myself, I urge your support of House File 5049. We have documented thousands of instances of parents with disabilities successfully raising children around the world, many of them right here in Minnesota. With your support, we can ensure that what happened to one of our members doesn't happen again. One of our members moved to this country in 2003, after which she learned how to live and work independently as a blind person. She earned her GED, her bachelor's, and her master's degree from the University of Minnesota. And now she holds a senior role in state government. The day after returning home from the hospital after the birth of her first daughter, she received a call from a social worker who said that she wanted to come check up on her and her baby. And at the time, the mom thought this was strange, but then again, maybe this was typical of what you'd expect as new parents here in the States. This social worker visited our member's home for several days, watching her feed, play with, change, and overall just take care of her child. And on the final day, the social worker said, "I don't have to worry anymore. You're doing fine." Well, of course she was doing fine. She had taken classes at HCMC. She had learned from her sister's experience as a mom. She had done everything she could to prepare for the arrival of her child. Now, our best guess is that a social worker looked at this kind-hearted, thoughtful, hardworking mom and thought that she was a danger to her child only because of her blindness. This mom is now the mom of two daughters that are both happy and healthy teenagers. You know, our member is still hurt and angered by this experience, thinking that somebody came into her home solely because of the misperceptions about her disability. And what we hope to do with this bill, and what we all wonder, is would this mom have been so fortunate if she hadn't been as educated and as prepared? Would she have been able to stay and care for her child, or would her child have been taken from her? We've seen the powerful impact that mentoring and hands-on demonstrations can have for parents with disabilities, learning the ropes and learning how to work confident and have confidence in themselves and in their abilities. So what this bill will aim to do is to make sure that the burden of proof is not about the person's disability, but it is about specific behaviors. And if the court determines that those specific behaviors are problematic and are endangering the life of a child, then offer that parent supportive parenting services. Offer them mentoring, offer them guidance, and make sure that they have the opportunity to demonstrate how those supportive techniques can make them an effective and safe parent. Sighted parents have the opportunity to raise their children with support. Parents with disabilities should have that same opportunity. Thank you for your consideration and for your support of this House file.
Thank you for your testimony. Next up, I have Callie and Serena Decker. Welcome to the committee. Please introduce yourself and proceed with your testimony.
Hi, I'm Serena and I am a hockey player.
Hi, I'm Callie Decker and I'm a hockey mom.
Bless you.
I'm in 3rd grade and I love to read. I like trying new things and going on adventures.
I love traveling and exploring new places and cultures. I'm a blind parent.
I'm a child of blind parents. I do Wordle with my dad. Even though he can do it on his own, we like to do it together. We also do other fun games like Uno and Scrabble.
We're the same as everyone else and just do things a little bit differently. We can't drive, which is probably the largest obstacle, but we get to ride in the back seat of the rideshare and chat with our kids. We play games and read books with print and braille. And we also do many things the same. I'm sure everybody is going to ask their family members what they're going to have for dinner tonight, right? Every night. We cook meals, maintain a home, we help with homework and travel within our community and even outside the country. We use our long white canes to navigate safely when doing so.
My parents inspire me, not because they're blind, but because they teach me, work hard, and are good parents. Let's score a goal for blind parents and families in Minnesota.
Thank you.
Thank you very much for your testimony. You did a very good job. I'm sure you're very good at hockey, too. I also play Wordle with my kids, even though I don't need their help. Sometimes they find things in spelling bee, though, that I don't find. Are there any other members of the public wishing to testify on this bill? All right, not seeing any, we'll move on to member discussion. Representative Scott.
Thank you, Madam Chair, and Representative Hicks. Just had just one really question, I guess, in the supportive parenting services. If you could elaborate on what that might look like, practically speaking, that'd be helpful for the committee, I think.
Representative Hicks.
Thank you, Chair, and thank you for the question, Representative Scott. In the DE amendment, we did tweak the language just a little bit, but as the testifiers talked about, there are lots of services to help people with disabilities learn how to navigate the world with their disability. For people with blindness, they shared some of those resources. For people with physical disabilities, other There are the Centers for Independent Living have resources and things to help. We also have Medicaid waivers and things like that that can assist with some of those things. We also have deaf and hard of hearing services for the deaf and the deaf-blind here in Minnesota that can help people navigate how to use those services. There are a lot of ways to learn how to live as a person with a disability, whether you've always had that disability or you acquire it. The assumption here is that able-bodied people and people without disabilities maybe don't know about those resources, and so they just assume that we don't have a community to take care of each other.
Representative Scott.
Thank you, Madam Chair, and thank you for that explanation. And I think that that's super helpful for people that have never lived with a disability. We're not familiar with a lot of those services that are available. That's why I asked the question. Thank you.
All right, Representative Johnson.
Chair Becker-Finn, members, Representative Hicks, thank you for bringing this forward. In my career in law enforcement, we actually dealt with this situation where it was not just one parent, both parents were blind. They had 3 young children. They did a great job with their raising those kids. Unfortunately, we had neighbors that would call in all the time because they had concerns. Not only do we need something like this, we also need to educate the public that these people can do the work they do, and they can do it fabulous. So thank you for bringing this forward.
Representative Finke.
Thank you, Chair Becker-Finn. Excuse me. And Representative Hicks, I also just want to thank you for this work that you are doing. I want to make sure that we continue to support specifically the work that you are doing to ensure that we lose this model of thinking that people with disabilities are somehow to be segmented out and treated differently. We know that that's not true. We know that parents with disabilities are just parents. We can just say parents, hopefully in the future. Appreciate all the testifiers who made the trip down here, and I'll continue to follow your lead on this important work. Thank you so much for it.
All right. With that, closing comments, Representative Hicks.
Thank you all so much for your support. Adoption, custody, child welfare is complicated. And it's full of, like was shared, people's perceptions. And we need to make sure that we're protecting parents and families, all parents and families. But we need language to do that for people with disabilities. And so this bill attempts to do that. So thank you for your support.
All right. With that, I will renew my motion to refer House File 5049 as amended to the Children and Families Finance and Policy Committee. All those in favor, please say aye. 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 Opposed? Motion prevails. Thank you, Representative Hicks. And with that, we are adjourned.